Hi, everybody. Welcome to this month's Facebook Live, Asset Protection 101. So I'm really excited to bring this topic to you. It has been a much requested topic. So I'm going to see if I can do it justice in an hour. Otherwise, we might do a follow-up depending on the number of questions. So thank you, everybody, for joining me today. Before I dive into the technical content, I did just want to acknowledge that today I'm hosting this training from the lands of the Ugamba people on the Gold Coast. I also acknowledge the traditional custodians of the lands on which each of you are living, learning, and working from today. I pay my respects to elders past, present, and emerging, and celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their ongoing cultures and connections to the lands and waters of Australia. So before I dive into the technical content, I just want to check that all the sound and tech and everything is working properly. If you are having any issues, you've got a comments or question box. So feel free to ask questions as we go. I can see those. I'm also just going to check that the live stream is coming up in the group. Yep, I can see myself back, which is awesome. So I'm going to dive into it. And yeah, feel free to ask questions as we go. So today's asset protection is really going to focus on bankruptcy. So there's different types of asset protection, obviously. The other probably most important one is family law. And when we talk in the estate planning context, sometimes we also talk about protecting assets from spendthrift beneficiaries or immature beneficiaries. But today I'm really just going to drill down into this bankruptcy context. So when I'm saying asset protection in today's webinar, what I'm really talking about is firstly protecting assets from the risks of different activities. So not exposing one activity to the risks of others that the same people might be carrying on or within a business structure. Segregating business risk from personal risk. So for instance, we don't want the family home and the personal wealth accumulation being on the line to satisfy things going wrong in a business context if we can avoid it. And then also segregating risk between different assets. So I'm going to focus on those three today. Before we do that, I want to bring to you some core principles. Okay, so things like limited liability, director liability, shareholder liability, beneficiary and trustee liability, this idea of the domino theory, at-risk and safe harbor spouses, and also clawback rules. This is what I'm hoping we can cover today. Now, when it comes to asset protection, what I'm going to be focusing on, I guess, is this third aspect of what makes best asset protection. So I like to think of asset protection a little bit like a three-legged stool. And obviously, if you've only got two stools, or two of these elements, then the stool gets very wobbly. And if you've only got one, then the whole thing falls over. So when I talk to clients about asset protection, I say, obviously, the first thing you want is best practice within your business or organization, right? You want everyone up to date with their CPD, following the professional guidelines, whatever it is. But the reality is that we are all human and people do make mistakes. So then the next line of defense is having the right insurances in place. Now, a lot of people just stop there. They say, look, I've got my professional indemnity or public liability insurance. I'm cool. The last leg of our stool, though, to really give you the optimal asset protection and to put you in a position of strength is to get your structuring right. So I'm going to be focusing on what are the sort of rules of thumb that we can look at when it comes to getting the structure right. So first concept, limited liability. You don't have to really read this, but you do know that in the Corporations Act, a company is a separate legal entity. It is separate from its owners, its managers, operators, employees, agents, all of that. The Corporations Act establishes that for us. So in reality, what that means is that this company is different from this other company on the right. And if there's a claim from a creditor against this first company, then we've got a big firewall so that only that first company has to satisfy the claim against them, right? And I'll just also say, I'm not an insolvency lawyer, but everybody should kind of know that there is a process that goes through once there's a claim, right? So there's got to be a claim made, and then a decision or a judgment ordered about satisfying that debt. So there's a whole sort of process to go through before this company might look at actually having to satisfy that creditor. And I'm not going to go into that today. Let's just assume for all of these examples that this creditor has received a judgment in their favor where the company has to, make a payment to them or something. This is really what we're talking about at the crux of it. So if this company has to, make a $2 million payment, they've done something wrong, I don't know, it's Lorna Jane saying, was it Lorna Jane or Lululemon saying that that their clothes protect from COVID, something like that, right? They've got a judgment against them. They've got to satisfy that. Even though we've got this connected structure, we might have a director who's the director of both companies. We've got a big firewall saying, well, you can't jump over to this other trading company to get their assets to satisfy the claim, and you can't go up the chain either. So maybe this first company does have to go into insolvency, have its assets liquidated to satisfy that chain. But with proper asset protection using limited liability concepts, we're not having the whole ship go down. Let's talk about shareholder liability. The number one principle that I really want you to take away is the difference between shareholder liability and director liability. So shareholders are not liable for the debts of their companies. Their only obligation is to pay the company any amount unpaid on their shares, right? This is different to director liability. So directors can be liable for the debts of the company if they have breached their director's duties. So they're not just straight up liable for the debts of the company. It's only if there is proven that they have breached their director's duties. So some of the director duties we're thinking about here are like trading while insolvent, failure to pay their tax debts, super guarantees, failure to meet workplace health and safety, or if they've given up personal guarantees. So it's not just because there is a claim against the company that a director will be personally liable. But obviously when advising people, you really do need to make sure directors understand their duties and their liabilities as well. So let's have a look. How would this work? If there was a claim, as we said, against this company, the shareholder is a trust here. The trust is not liable. It's just a shareholder, and they themselves cannot, the assets in the trust and even the trustee are not available to satisfy the debts if there's a claim against our trading company, right? So not only do we have limited liability giving us segregation between, these true companies, we also have limited liability going up the chain as well. So a shareholder is not liable for the debts of a company. You would have to have a look at the directorship though. So if the director was held to be in breach of their duties, then they could be personally liable and attached to an action against this trading company. And if this director was in fact the shareholder, then their shares in the company could also be available. But generally speaking, shareholders are not liable for the debts of a company. So this is a good example. This is a really simple example. You don't see too much of this at the moment, but there are historical examples of a lot of people, setting up their company. Like if they were a mum and dad and they set this company up before discretionary trusts really took off, or just trying to keep this simple. So we've got husband and wife, and husband is the director. Now, if he did breach his duties as part of the claim, I don't know, let's say there were unpaid debts to creditors, and really it was found that not only were there unpaid debts, but they were trading insolvently, then the creditors could go, okay, we're going to take everything that's any assets that are in this company, anything in the bank account, any property it has, all of that. But we're also going to come after our director as well. So not only does the creditor or the trustee in bankruptcy, because what would probably happen is this company is forced to go through the insolvency process or administration to satisfy the creditor's claim against them or the judgment against them. So the trustee in bankruptcy would go through that, but then the trustee in bankruptcy could also go after the director, and they would get control of his shares and anything personally that he held. So general rule of thumb is directors should not be shareholders if you can help it. And I'll talk a little bit about this low risk, high risk spouse and safe haven kind of concept in a few moments. So that's kind of it on companies. And I've got some examples to work through, and we'll say, well, is this a good structure or not? But before we go through that, I want to talk about the sort of equivalent principles for trusts. So really what I'm talking about here is discretionary trusts. And this is out of estate planning. So I'm talking about family trusts that people set up during their lifetime. And the same principles pretty much apply as well for testamentary trusts as well, testamentary discretionary trusts. So hopefully you're all pretty much familiar or have seen this diagram before. The key element of a discretionary trust is that we separate control of the assets in the trust from the right to benefit from those assets. So the people who can benefit are called the beneficiaries. That's pretty easy to remember, right? And the people who are in control are the trustee and perhaps the appointer. Sometimes that appointer role is called a principal or a guardian, or sometimes it doesn't even exist because it is optional. So the trustee is probably the one to focus on. The trustee has the day-to-day management of the trust. They are also recorded as the legal owner of the trust assets, and they hold those assets subject to a fiduciary duty for the beneficiaries. Now, a discretionary trust will typically have a large range of people who can benefit, and the trustee has to choose which of those beneficiaries get a benefit, how much and when, and they really have total discretion about how they do that, provided they consider all of the beneficiaries and manage the trust for the beneficiaries in their best interests. So in a discretionary trust, the beneficiaries really just have a right to be considered. They cannot demand a distribution, and they also have a right for due administration of the trust. Now, this point is critical. No beneficiary owns the trust assets. And that's because their entitlement to receive a benefit is totally at the discretion of the trustee. So in one year, they could receive 100%, another year they could receive 0%. Their entitlement is not set. It could be 0 or 100. So that principle is really critical to remember about why beneficiaries do not own the trust assets. And that's like the most important thing. If you take anything out of today, it's remembering that the beneficiaries cannot own the trust assets. And that's why, for instance, a discretionary trust is so much more powerful than a fixed trust when it comes to asset protection. So what that means in practical terms is that if a beneficiary is sued, and just because they're listed in the class of beneficiaries, the assets in the trust should not be available to satisfy their creditors. The assets in the trust should be separate, ring-fenced, and not on the table. Let's contrast that with the trustees. A trustee is liable for the debts of the trust. So if there's a claim against the trustee is liable. They're personally liable. Now, they have a right of indemnity against the trust assets, so they can use the assets in the trust to satisfy that claim first. But if there's insufficient assets in the trust, once those assets are exhausted, the trustee becomes personally liable. Anything that they own is on the table to satisfy that claim. So this is where people like to double down with a corporate trustee. So we can use a corporate trustee and that limited liability concept to basically limit the right of the trustee so that even if they are personally liable, their assets, their personal assets aren't on the table. So the general rule of thumb is if your trust only owns passive assets, an individual trust is okay. But if the trust holds assets that are risky, where they could be sued because they're holding those assets, use a corporate trustee. Now, I'm going to dive into those concepts in a moment, but I will have a diagram I want to talk you through. So we've got our Madam Trustee here, our individual trustee. Now, let's say this is me, Tara. I'm the trustee and I have a family home and some cash. Now, those are obviously my personal family assets that shouldn't be associated with like my business stuff. So here, if I'm the sole trustee of the trust and there is a claim against the trust for a creditor, then I'm personally liable. Whatever we've got in the trust can be sold up to satisfy that, but then they can actually go, if they exhaust those assets in the trust and there's still a debt outstanding, they can go and access my home and my bank accounts to satisfy a claim. Contrast that with if we have limited liability. So instead of being the trustee, I'm actually the shareholder of the trustee, and maybe I and my husband are the directors. I'll put me in there too. Now this is just like a $2 company, right? So the company doesn't do anything. It is just a trustee. So we settled it and it might just have, you know, 1 or 2 ordinary shares, a share capital paid up of $1 or $2. So if there's a claim against the trust by a creditor, now the assets in the trust still available to satisfy that claim. But if the assets do not satisfy the debt fully, and they can go, okay, well, we're going to go up to the trustee and access their personal liability. Now, all they can access is this $2 because we have the benefit of the limited liability structure and the shareholder and director nuances of a company. So we just went through this. Individual shareholders or any shareholder is not liable for the debts of the company. So let's use some dollars, actually. We've got a $2 million claim. This trust only has $1 million of assets. So they're then going after the trustee company for that remaining $1 million. But the trustee company only has $2 in its bank account. So shareholders are not liable for the debts of a company. So there's a big firewall. They can't go up this chain any further to attack me and my personal assets. Unless the directors have breached their duties, which, you know, usually that's not common. You really have to be like doing the wrong thing. So like, you know, if it's like just a claim against the business for negligence or product failure or whatever, even misleading and deceptive conduct, anything like that, you know, that's not directors' duties being breached. So the directors shouldn't be personally liable either. So what happens is the creditor just misses out. You know, they wind up the trustee company. It's only worth $2. Maybe they'll have a crack at shareholders and directors, but the limited liability concepts save us. So the creditor does miss out. They only get their $1 million, but my family home, bank accounts, all of that is protected. It's not on the line. So, you know, this is why, like, people go to jail, like Alan Bond, they go to jail for crime, white-collar crime, and then they come out and they still have access to all of their assets and their wealth because of limited liability. Can we talk a little bit about RICHSTAR and this case impacting on the discretionary trust protection of beneficiaries? Who's heard of RICHSTAR? It's been around. I think it was a 2008 decision. Now, I'm not doing like the full case review on it because we are on a little bit of a timeline. I've got to wrap this up by 1. But basically, this case really got people feeling very nervous about the asset protection benefits of trusts. So it was a single court judge Western Australian decision, but which, like, on its face, it's like, who cares? That's just one random single court judge decision out of a whole bunch of decisions. But it was by Justice French, who later became the Chief Justice of the High Court. So it did get everybody really concerned about whether we were going to see a shift in principles coming down the High Court. Now, this decision actually kind of fizzled out. It has been discussed in following cases as no longer being good authority, and we never really did see any kind of shift in principles coming out of the High Court. So I think now you don't really have to worry about RICHSTAR, but I want to just talk to you about what the decision held and what some of the principles were that got everyone worried, because it might be that some of those, you've heard some of those principles and they're in the back of your head as making you feel worried, and you can probably discard them. So basically we had a situation, have I got another slide? Yeah, where we had, I'll just pick on me again, but obviously it was a fellow. So we had one person being the trustee and the appointor, personal trustee, and that same person was also the beneficiary. And now there was a discretionary trust that had a claim come against it. So there was a full class of beneficiaries like that you would typically see in a discretionary trust. So like parents, children, I'm not sure if they were spouses or not, but parents, children, nieces, nephews, aunts, uncles, cousins, discretionary trusts that they were connected with, companies they were all connected with, that kind of thing. But in reality, this was a single person. So they didn't really have any kids, and all of the distributions from the trust were going to them. So when you look at this, if you follow the vibe of it, from the castle, if you go back to Dennis Denuto's legal principles and follow the vibe, it kind of looks and feels like the assets in this trust really belong to our individual beneficiary, right? So there was a freezing order. The RICHSTAR decision, and I think it was all about the West Point auto collapse that happened in Western Australia. The RICHSTAR decision really said, well, you know what, because we've got this one individual connected with everything, and there was a claim, the claim was against that individual separately. And he was saying that the assets in the discretionary trust were not available to satisfy the claim against our individual. So the judgment in RICHSTAR said, well, actually, even though beneficiaries should not have ownership assets in the discretionary trust, it kind of looks and feels like the assets here are his assets or her assets. So we've got the same person being trustee, appointer, and beneficiary. And on that basis, they actually granted a freezing order over the assets in the discretionary trust, so they could not be dealt with until it was further considered if they can be available to satisfy this claim. So that really went against typical trust protection principles, right? Because just by virtue of being a beneficiary does not mean that the assets of the trust belong to this individual. There's no claim against this individual in their role as trustee and appointer either. So they are a separate legal entity. This trust should be totally separate. So that's what happened in RICHSTAR. But it got people spooked, saying, oh, well, you shouldn't have the same person as the trustee and appointer or our at-risk person as being a beneficiary. Now, technically, it's still probably better to just have your low-risk spouse as an appointer, and if you've got a passive trust, your low-risk spouse as the trustee, or if you've got a high risky trust, your high-risk spouse as the trustee. But RICHSTAR is not really good authority for that anymore. Another thing I'll just mention is that property vests in the appointer power is not property that is going to vest in the trustee in bankruptcy. So if, for instance, this person was going through bankruptcy, just because they are an appointer here does not mean that the trustee in bankruptcy substitutes for them. It's not property for that now. So I just wanted to mention that. I can see Kenneth has asked a question. Thank you for that. You might have come on a bit later and missed this section, but a director will breach their duties when they're doing things like insolvent trading, anything where they haven't satisfied their super guarantee obligations or tax debts with the ATO, failure to meet workplace health and safety, that type of thing, and also a call on personal guarantees. If they've given that up, then obviously that's a way for a director to be personally liable as well. So I'll just go back to what we're talking about. Our next common or like foundation theory, which is the domino theory. So, I mean, I don't think the domino theory, you probably won't find that in any legislation. And it's kind of the same as like having all your eggs in one basket, right? Fundamental to this domino theory is understanding which assets are passive or low risk and which assets are high risk. Now, when I'm talking about risk, basically my rule of thumb is if you own this asset, can someone sue you, or is someone likely to sue you because you own that asset, and are you able to lose more than the value of the asset? So let's look at some of these passive examples. We've just been through the fact that shareholders in proprietary limited listed companies cannot be personally liable for the debts of the company. The worst thing that can happen is they lose up the paid up capital in that company, right? So you lose like your share value goes to zero. That's the worst thing that can happen. Same with like if you're making loans out to people, right? The worst thing that happens is it becomes a bad debt and you never get paid. You're not going to like go into the hole though because of that asset. Same with cash, same with bonds. I would say these are passive, low risk assets. Compare that with trading businesses, plant and equipment where people could have an injury or it could, injure somebody and you get like a claim against you for personal liability, employee issues. They can sue you for all kinds of things. Commercial property, again, injury issues, public liability, investment property, same kind of thing. So all of these assets, you can lose not only the value of that asset, but you can actually have a liability greater than the value of the asset arise. Hope that makes sense. Now, it is really interesting talking to clients because technically like an investment property is on the risky side, but a lot of them don't view their assets as being that risky. So you do kind of, I guess, have to take a pragmatic view here about like an investment property with a long-term tenant where you have got landlord insurance and all of that. Like really, officially, it's a risky asset where you could be sued. But in reality, it's very unlikely, or like insurance will usually be enough. So when you're talking to clients, you might have to sort of go, well, which assets are really the ones that are keeping you up at night? And if you're going to take steps to rearrange the deck chairs and change ownership structures, which ones are you really going to be worried about? Maybe you could, is it worth incurring stamp duty or tax consequences to increase the protection of an investment property when in reality the client's not that concerned about losing or being sued more than the value of the property? So an easy way to remember it is it's like, don't put all your eggs in one basket. So if we have a look here, we've got sort of two examples. This first example, I just want to check what I've got. So family trust number one, it has, as you can see, a combination of risky and passive assets. And probably the riskiest one would be the trading business, right? This number one structure on the left is really not ideal for a few reasons. Firstly, if something goes pear-shaped in our trading business, it puts all of our other assets at risk, right? Like the listed shares, the shares in the proprietary limited company, the cash, nothing should go wrong with those. But suddenly they're on the table and they could all be lost if there's a big claim against this trading business. Secondly, we have our individual trustee. So this individual trustee is personally liable for the assets, the debts of this trust. So again, even if these assets are not enough to satisfy the debt, let's say the debt is $2 million, these all add up to $1 million, they're going to come after this trustee for $1 million, and they totally can do it. Anything that they own personally is on the table to satisfy that claim. So it's a bad structure for asset protection. The second one on the right, a little bit better. We've got our limited liability in the trustee now. So again, if we've got our $2 million claim, if we've got our $2 million claim from the creditor, these assets are up to $1 million. So we're still breaching our domino theory, right? Because we've got our low risk assets satisfying claims against our high risk assets that really shouldn't be on the table. But if those only satisfy half of the debt, they're going to try and go that extra $1 million against that trustee. But the trustee only has, $2 worth of shares. Can't go up the chain to access the personal assets of our shareholder. If the director has not breached their duties, you can't access their personal assets either. So this is a little bit better of a structure, but really the best thing to do, would be to separate these out so that you have listed shares in all the passive assets in one and the high risk assets in another. So as you can sort of see here, this is an ideal structure. It's okay to have a individual trustee where your trust only has passive assets, which we've got, these are the passive assets down here, right? Because you're never going to get sued for owning these. The worst thing happens is the asset value goes down to zero. Too sad. But the commercial property, if we have it in a separate trust, which has its own corporate trustee, so that the personal assets of the shareholders and directors aren't available, and then we have another trust separating out again our trading business. So if something goes pear-shaped with the trading business, there's big firewalls between our other trusts. The assets that are in those other trusts are not on the table to satisfy the claim. So again, we've got our $2 million claim. It's only whatever's in this risky family trust number 2 that's really up for grabs to satisfy the claim. They blow that up, move on. At least they've still got their other assets. So this is combining the separate legal entity concept and the domino theory plus the limited liability concept. So another example here, which is not an ideal. So this is kind of dragging in from that first example we did where the family trust is the shareholder. But this structure is bad as well. It's not good for asset protection because what we're doing is tainting our shares in the company with a commercial property trading business. So if there's a problem with business up here, everything below this line is up for grabs. So whatever's going on down here, whatever's going down here, the whole structure is exposed to a claim against the commercial property or the trading business. So if you're going to have a shareholder trust, it really can't do anything else except have passive assets. So you could have cash, tick bonds, listed shares, and loans. That's a great question. So you could have cash. Excuse me, I'm just looking at the questions. That's a great question, Michael, about loans becoming an issue with asset protection. Absolutely. So if you have, let's go back to the RICHSTAR example where they were trying to get the assets in the discretionary trust over to satisfy the claim against the individual. Now, if this trust had unpaid present entitlements owing to this individual, or if they had made a loan to the trust, like an at-call loan, any event where like the balance sheet of the trust had said that it was owing money to our individual, then that is leakage, which would undermine this principle. And the trustee in bankruptcy, if this individual had gone into bankruptcy, could actually draw on those unpaid present entitlements or that loan to have them repaid and to satisfy the creditor. So yeah, absolutely. That's an excellent point. You do have to be really careful with your loan accounts, because that is one thing. Same as in estate planning, right? Like that's one thing. These loan accounts really undermine the separation between the legal entities. So where are we up to? So this is really like best practice structure here. Sometimes they will want to combine like a commercial property and a trading business. Pure best practice would say keep them separate, but obviously clients are driven, and sometimes accountants too, by minimizing the number of structures that they have. And so sometimes they might want to group risky assets with passive assets. You know, it is what it is. You just assess the risk, but like the rule of thumb, don't taint a low risk passive trust with risky assets. You can have as many passive assets in a single trust as you want, but try to at least keep your risky assets in another structure. And what some people do, you know, when you look at these businesses that have a lot going on, a lot of assets, a lot of properties, a lot of different, you know, sub franchises or whatever, you know, sometimes they just say, well, we're going to pick a value. We're not going to do a different trust for every property, but we're going to say, you know, once this trust has more than $10 million worth of assets in it, we're going to set up another one or something like that, just so you can say, well, at least we're not putting everything on the table and exposing it. You know, we're kind of still kind of being pragmatic about not overcomplicating it with too many trusts, but we're going to limit our exposure for each vehicle as well. So a lot of this comes down to really being pragmatic. The one thing I will say is like, and we'll talk about this in the bankruptcy section, but if you can get your structure right from the beginning, it just saves so much angst, tax, stamp duty, all of that. So I've touched on this idea of low risk and high risk spouse. So when you're dealing with a couple, this is important. And obviously I'm being very generalizing here, because you don't always have couples, or you might have two high risk spouses, right? Like this isn't going to apply to everybody. So this is my assessment of, if you tick kind of any of these, you're possibly a high risk spouse. So if you're a director of a company or a trading entity, if you're in a profession where you're at risk of a negligence claim, so like doctors, engineers, lawyers, that kind of thing, accountants, financial advisors, all of that. If you're trading in your own name personally, or even if you're giving personal guarantees, I would say we need to look at you through the lens of you being higher risk. So I think that's always worthwhile doing at the start of any exercise. And the general rule is that you don't want like the high risk spouse, in this case our male person, to be a shareholder. So really you want, if your high risk spouse is on the left, you really want anyone with high risk to be all the directorships of everything, give all the personal guarantees, and then they should not own any assets. They shouldn't own the personal home. They shouldn't have the bank account in their name. They shouldn't be a shareholder. Don't give them UPEs or loans. Ideally, they won't be the appointer or principal guardian. Now, that is a throwback to that RICHSTAR, which is probably like not a big deal, but you know, it's still kind of, people still do that because of RICHSTAR, and you don't technically have to, but it kind of does also, you know, if you're going to keep all control or have it align with the shareholder, you might as well, but it's really not like a huge point. If you've got a high risk trust and they insist on having an individual trustee, then at least make sure it's your high risk spouse. Do not let them be the trustee of a passive trust, and set up the estate plan so that high-risk person is not receiving any assets in their name, use the testamentary trust. Compare that with your low-risk spouse. Don't make your low-risk spouse the director, but do make them the shareholder. Don't make your low-risk spouse an individual trustee of a high-risk trust, but they can be the trustee of a passive trust. Really, you should load up all personal assets in the name of the low-risk spouse, so like the home or bank accounts, and don't let them give guarantees, trade in their own name. And because you've loaded up all the assets into their name, when it comes to estate planning, don't have an I love you will, use a testamentary trust will. Now, I will make these slides available so you don't have to scrabble to write all this down. I'm just going to read the question from Trent. Thanks, Trent. Does removing the trading company director as a shareholder of the corporate trustee and an appointer add an extra layer of protection? Yeah, it does. Definitely the shareholder element. Just because if they do become sued personally, at least the trustee in bankruptcy doesn't become the shareholder. And then whoever is the low-risk spouse can appoint a different director and maintain control of the trustee initially. And I would change them as appointer, but the trustee in bankruptcy can't technically stand in their shoes as through that appointer role. So it's probably okay if you don't have them as the appointer, but I think it's just easier to have the low-risk spouse as the appointer anyway. So just the question doesn't even arise. The idea of changing the appointer really comes from that RICHSTAR decision, which has been proven as not being good law anymore. I'll also just mention some states do and some states don't have corporate trustee stamp duty. So I know in Queensland where I am, you do have to be careful when you're transferring shares in a corporate trustee, even though they're worth $2. The stamps office says, well, actually, we're going to look at the dutiable, valuable property of the trust assets of which that company is the trustee, because we're kind of assuming that what you're doing is transferring the assets in the trust. There's exemptions when you are transferring them to spouses and people in a family, but you just have to go through that process. I don't think every state has it. In fact, I think Queensland is an outlier with having that, but depending on your state, that would just be worth checking because it adds a little bit more complication than just saying, oh, it's a transfer of a $2 company. So if we go back to our example here, let's say our husband is the high-risk spouse. So I would not want him to be the shareholder. We would want our wife, and excuse me for using husband and wife. I know that's not very progressive, but I'm going to do it for today. So our wife would be the shareholder. Ideally, the home should be 100% in her name, or maybe 99%, 1% kind of thing. But you would load up the assets in the low-risk spouse's name and all the exposure and, personal guarantees, directorship, all of that in the high-risk spouse's name. And ideally, he would own nothing. So I want to just talk about the trustee and bankruptcy clawback rule. So if you are looking at rearranging an existing structure, that you have to look at these first, right? Because sometimes it's just not worth doing it. So I always check with the clients. Are you currently being sued? Are you on notice that there is a claim against you or coming? Are you presently insolvent? Have you got any of these outstanding obligations? Because if any of these, if you can tick any of these, just stop. There's no point in really moving anything around because you will be, the trustee and bankruptcy clawback rules will unwind everything that you've done. So, look, an insolvency lawyer will be able to sort of guide you through the nuances of this better than I can, but I'm going to sort of just want to get these on your radar. So, for instance, if you are acting for someone who is trying to unwind a transaction or someone who has like claims looming, get like an insolvency lawyer involved. But if you've just got a totally clear slate, and like there are cases where they're basically like, if you're a prudent professional, you've got no known claims against you, and you're just trying to do the best that you can to access or take advantage of, some of these concepts like limited liability, then that's cool. You're not trying to defeat creditors. But if you're doing anything to defeat a creditor that is a known specific creditor, then you're in this unlimited clawback space. So basically, they say the transfer was void against the trustee in bankruptcy. So basically what that means is, if you are going through bankrupt and saying, oh, I don't have these assets because I transferred them away, the trustee can unwind that and drag those assets back into your name and make them available to satisfy the claim. So there is an unlimited clawback period if you transferred an asset or did anything with a main purpose to defeat or hinder creditors. Now, I think when you look at the definition of transfer in the Bankruptcy Act as well, it's pretty broad. Don't hold me on that, but I think it extends to things like forgiving debts and all, it's not just like a transfer. So this is a question of fact. If you're doing something and your main purpose is to defeat or hinder creditors, then you are, they can unwind it indefinitely 20 years later. And there is a presumption that you were insolvent at the time of the transfer. So this does not apply if market value consideration was paid. So you transferred your house, your interest in the house, to your wife or your spouse, and they paid you the cash, because then obviously the cash is on the table instead of the interest in the house. It's the same from the trustee's perspective. If the transferee did not know the purpose was to defeat creditors and they could not have inferred that you were insolvent, then it doesn't apply. But this is a real worry, right? So this is why you need to make sure that your client that you do this early. The next one, which applies, is 4.5 years. So this pretty much applies to everyone. So even if there is no known creditor or any issue, any transaction that you enter into to improve your asset protection, which involves you like transferring assets away, has a 4.5 year clawback to anyone, right? So this is what I say to clients. If you're thinking about this, don't sit on it. Just make the decision early and do it, because that you need to get that clock ticking on that 4.5 year period. And I've seen a lot of clients like they go, and I'm not sure, and should I pay the duty and blah, blah, blah. And then a year goes by and then they decide to do it. And it's like, you could be only 3.5 years on your clawback, but you've delayed for so long that your asset protection is delayed by another 4.5 years. You're looking at 5.5 years, right? So if you transfer for less than market value consideration, then again, you've got a 4.5 year period. So this is really important. Like you don't get immediate protection on day one. Natural love and affection between spouses is not consideration. You also have to be careful about the increases in the value. So if you do have an asset that was worth X amount, like $1 million, on the day you transferred it, and then when it's clawed back, it's worth $2 million. Well, the $2 million is available to satisfy the creditor. You don't get the protection of the value of the date. Sometimes people do things like, how do I explain this? They do a vendor financed, they transfer the property for consideration, but they do like a vendor financed loan so that, and then the loan is like forgiven. So the thing that is clawed back is not the property, but the loan, and the loan is like a set amount. So you're actually locking in place like the value at the time of the transfer, not the increase in the property. So if you are looking at doing that, I don't have time to go into that today, but that's worth just talking to the lawyer who's helping you or the accountant who's helping you with that, considering, well, can we do like a vendor finance loan that's forgiven so that we lock in the value that's clawed back. You also have to really look at the purpose. That's absolutely critical. So I would suggest if you're looking at transferring any assets at all, document contemporaneously the purpose, say it's part of an estate planning thing, part of business continuity, I don't care. Just make sure that the purpose is documented, and the purpose is not to defeat creditors. And also get a statement of solvency prepared by the accountant at the same date so that it's very clear that you are not insolvent. Because if you're insolvent at the time you transfer, then the clawback is unlimited. So you need your statement of solvency so that you move from the unlimited clawback through to at least the 4.5-year clawback. And I don't have really any tricks to avoid this 4.5-year clawback. It is what it is. Like, so for instance, 12, oh, is that 12? Yeah, 12 years later, I just had a little brain fart then. You know, like this case, Wallace and Wallace, the home was transferred for natural love and affection to the wife. 12 years later, he went into bankruptcy and it was clawed back. You know, like this is how these rules work. They are serious and they're really worth considering. Now, if you set the structure up correctly from the beginning, then you don't have to worry about this clawback, right? So that's really worth drilling into your clients. Like, if you're going to be giving them advice on this, then make sure that they see you before they sign contracts and buy things. Now, obviously, we don't have the benefit of that for everybody, but you know, if you have got a clean slate, set it up in the beginning. I don't know if I've covered it here, but obviously, this doesn't even touch on this capital gains tax and the stamp duty consequences of moving assets as well. Can we talk about the family home? This is not my home, but I wish it was. Best principle is own the home 100% in our low-risk spouse name. And then on the estate planning front, make sure their will is updated so that the house passes appropriately on their death, like ideally into a testamentary trust if the recipient is a high-risk spouse. Sometimes you can have 1% in the high-risk spouse name and 99% in the low-risk spouse name. Now, they just do that so that like the high-risk spouse the low-risk spouse can't go and like sell the home without the high-risk spouse being a party to it. Now, you know, you're only exposing like 1% of the value here, but that high-risk spouse kind of has a veto power and can't have transactions happen to that asset. You know, they can't. If you're trying to like encumber that asset with a mortgage or put it up as security or something like that, you know, at least the 1% means the high risk spouse has a seat at the table. So sometimes people prefer to go with the 1%, 99%. I'll just say when it comes to family law, like none of this is relevant. The family courts don't really look at the percentages when it comes to their property splits, and they really just throw the house into the property pool and then apply it. So sometimes clients will be really worried about that when you're presenting this as an option. It works for bankruptcy, irrelevant for family law. And then if there is no low-risk spouse, sometimes you can do the principal place of residence, the gift and loan back arrangement, so that you have an individual owning the property rather than it going into like a family trust, because to get the principal place of residence CGT exemption, you can't have the asset owned by family trust. There are exemptions if it's in a testamentary trust and there's rights to occupy and that kind of thing. But, you know, if you've either got two high-risk spouses or just one person who's not in a relationship or anything, the gift and loan back can be useful. Now, I've done a separate training on gift and loan back, so I won't talk about that. But I will just mention the 4.5 years clawback applies to the gift and loan back unless you set it up the right way from the beginning as well. I want to just mention the estate plan. Like, don't let somebody dying unwind all the hard work that you've done to get the structuring right. So it's really important that if you've set up a client with these principles, that we don't want our low-risk spouse who's loaded up with all the assets dying and everything going under an I love you will to a high-risk spouse. And all of a sudden, you know, they've gone from a beautiful asset protection structure to owning all of these assets and exposing them to their risk liability. And then everyone's scrambling to look at how do we get them out of their name. We've got a clawback period, all of that. So moving assets like from an individual into a testamentary trust under a death event is not subject to the clawback. So death can be, I don't want to say opportunity, that sounds very insensitive, but it is a pathway for getting assets into the right structure without tax, without stamp duty, and without clawback. So it is really important to get the strategy for the estate planning right. And the huge one is the testamentary trust. Also review joint tenancy, joint bank accounts, and use the estate plan as a pathway to restructure. Now, if you've done my online course, then you'll know all about these points here. So yeah, I would probably just recommend diving. If you're not really sure what I'm talking about, dive into the online course and go through that.